Good afternoon, ladies and gentlemen. Thank you for joining in. Hope you are hope you all are having a pleasant day. It's great to be back again this week with another episode of Strata Talk Show. Today is our 46th episode. Um, Welcome everyone to 46th episode of the Strata Talk Show, brought to you by Excel Academy of Real Estate. For today, we will be discussing role of developer during JMB management period. Joining us today is Mr. Patrick Sebastian. He's an advocate and solicitor of the High Court of Malaya. If you guys have any question to Mr. Patrick, please do leave your question at the comment section below. We will address at the Q&A session at the end of our Strata Talk Show later. So without wasting our time, join me at welcoming Mr. Patrick. Welcome, sir.
All right, thank you very much. Good afternoon once again to each and every one of you. Thank you for joining in. My apologies, a slight delay caused because this morning I was in Ipoh for a case, and when I was coming back, I did not realize that one of my clients had changed lawyers, and I was on record for an appeal matter as well, which was supposed to be by Zoom at 2. Then they said it's 2:30. By the time the judge came on board to give a decision, it was almost 3 o'clock. So there was a slight delay there. So thank you for your patience. Now, I was asked a question. What topic would I like to briefly, of course, this is just a 1 hour session. What topic would I like to briefly touch on today? I think I've spoken at some length in the past about common property. I've also spoken about the maintenance fund and the sinking fund account, for what purposes it can be used. So we have spoken about quite a number of issues. And then it struck me that in recent times, in some of my cases, one of the issues that arose is, what is the role, what is the function of the developer during the JMB management period, when the JMB is managing the place? And more recently also, I have had several inquiries about this. So I thought I might just give a kind of an introductory talk today, something to ponder about. I'm not sure whether your Strata project has this issue, or if you're working for a developer, they may want to know what it is all about. So let's get into this issue, which is, in my opinion, a gray area. Okay, why? First of all, let's take it from the beginning. The developer builds the place and he completes the project and he hands over the key or vacant possession to the purchasers. Now, there are two possible scenarios. Scenario number one is, at the point of handing vacant possession to the developer, the Strata register book has already been opened. Now, if the Strata register book has already been opened, then by provision of law, the management corporation automatically comes into existence. This is provided for in the Strata Titles Act 1985 as amended, because titles and management corporations, all these, and Strata register books all come under titles. So the Strata Titles Act provides that if at the time of vacant possession, the Strata register book is open and MC already is incorporated. And when the MC is incorporated, all common property vests in the MC. Please take note of that. All common property vests in the MC. So from the developer, the common property which has been highlighted by the developer will all vest into the MC. No changes, no alterations, no amendments can be made thereafter. However, the MC does not take charge of the project. They do not take charge of management because the MC is only activated when it holds its first AGM and a management committee is elected. Now, for the management committee to be elected and for the first AGM to take place, an aggregate of 1/4 of the share units must have been issued. So, in other words, the developer would have sent out letters to all purchasers and inviting them to come and apply for their individual strata titles. He may, in normal practice, he will even recommend his own lawyers and say, please, you can contact these lawyers. Of course, you are free to use your own lawyers as well. So, the developer issues. And there comes the situation where many owners do not actually proceed to go and do this because they will have to get the Form 14A done and stamp duty is payable. So we are buying a property for about 600,000. You're going to pay about $18,000-$20,000 stamp duty easily. So they try to hold back. Okay, but the problem is until you hit 1/4, you cannot have the first AGM and the MC cannot take over. However, there are two safeguards as far as MC is concerned. Number one, the moment the strata register book is open and the management corporation comes into existence, the common property automatically vests into the MC. So it safeguards the common assets from the developer. Even if the developer subsequently should become liquidated, which is not very uncommon, there's no issue because this is vested there. Further, if you were to look at some of the provisions of the Act, for example, Section 50 of the Strata Management Act, it provides that the developer has to open a management account, maintenance account, in the name of the MC. And in Section 51, the developer has to open a sinking fund account in the name of the MC. So it is not in the developer's name, but it is in the MC's name. So, and the statute also provides that the maintenance fund and the sinking fund do not belong to the developer. So it's very clear cut. The developer cannot do with the common property as he likes because it is already vested into the MC, and the maintenance fund and sinking fund accounts are also in the name of the MC. Just that the developer runs the show on behalf of the MC. So that much is clear as far as the law is concerned. So we have no issues of that. Should the developer misuse or abuse their position, then of course breach of trust, criminal breach of trust, fiduciary breach, all these things can be brought against the developer. No issues at all. However, when it comes to the JMB, then it is a different story. Now, the JMB is formed in the second scenario where at the handing over of vacant possession, the strata register book has not been opened as yet. So if within 12 months of handing over vacant possession, the strata register book has not been opened, then it is the developer's duty to convene the first AGM of the JMB, and the Act, the SMA 2013 provides that the JMB comes into existence at the first AGM. So please take note, 12 months after handing over of vacant possession, unless a developer can get an adjournment of it, he has to call for the first AGM. It is at that first AGM that the JMB is actually formed. Now, the key difference between the JMB and the MC is, number one, first and foremost, MC constitutes of all registered owners only. So the statute uses words like registered proprietor. If you have not extracted or perfected your individual title, even though there may be an MC, you are technically not a member of the MC. You may attend meetings, you may even speak, but you cannot vote because you are not in that full sense of the word, a member of the MC. On the other hand, for JMB, the statute uses the word purchases. You are a purchaser of that parcel, but you have not perfected your title as yet. Since the strata register book has not been opened, so within 12 months of VP, first AGM of JMB, and the JMB comes into existence. The second key difference is when it concerns the MC, the common property automatically vests into the MC. So according to the development order, according to the strata role, according to the strata plan, and according to any amendments of your development order or building plans, as you may call it, as the architect submits to the land office and to the council, all those which are shown to be common property, inclusive of the management office, will have to be registered under the name of the MC. However, insofar as the JMB is concerned, the JMB cannot own any immovable property. So the JMB is not the owner of the common property. The developer continues to be the owner of the common property. And this is where, in the last few years, we have had cases where, during the JMB period, right, what the developer can and cannot do becomes an issue. Furthermore, the Act also specifically provides that the JMB shall constitute of the developer and the purchasers, right? Developer and purchasers. And the JMC, the Joint Management Committee, must also have a developer's representative there. Now, if there are many unsold units, it is highly probable the developer becomes the main or the person with the majority in the JMB, and therefore they can make all kinds of decisions which will be favorable to the developer. Can the developer interfere with the common property during the JMB period? Can the developer, for example, make amendments to the building plans which affects the common property? Can he do that? Now, this is a question that is very interesting because there are several cases along this line. And what is the answer to that? If the JMB were to go to court and say, no, you have already handed over management to us, therefore you cannot make any changes anymore, even though the common property, the master title is still in your name, then, of course, when you go to court, a simple question for the court is, where is your authority for saying so? Where do you get the authority? And this is the part that we have to look into very, very carefully, right? Now, let's look at one of the key sections which is relevant to us here. And this key section is section 15. When you look at section 15, 1.5 of your Strata Management Act, it says, a developer shall, before the developer's management period expires, transfer all balances of monies in the maintenance account and the sinking fund account to the joint management body. So all monies, okay. Now please note, not after the first AGM, before the developer's management period expires, they have to transfer to the JMB, hand over to the joint management body, the administrative office, which is your management office, the audited accounts has to be handed over, all records. This is where, for those of you who are familiar, there will be a borang empat. In the borang empat, they have to list down all the records, all the manuals, all the contracts, etc., which are to be handed over from developer to JMB. If the JMB has doubts or reservations about whether the borang empat is a complete list, you should not accept borang empat, right? Because once you accept it, it's deemed that they have already handed everything over to you. But I want to point out a very important thing. Section 15, subsection 1, right? In paragraph B, Roman 3 says all the assets of the development area. So it is the duty of the developer to hand over all assets of the development area. So in other words, when a project is developed, 2, 3 buildings or as many buildings as you want, however tall they are, whatever common facilities you have, swimming pool, gym, maybe tennis court or a squash court, games room, whatever it is, everything has to be handed over to the JMB, even though it may still be in the name of the developer. Note that JMB can only own movable property. They cannot own immovable assets. But the handing over, as stipulated in section 15, clearly provides a guideline that the developer will be holding all these on trust for the JMB until the MC is created and everything is transferred to the MC. So the developer cannot make any changes as and when he likes. Number 2, it is now under the amendments, the strata roll has to be displayed at the sales office of the developer. And the Act says where it can be prominently seen by all purchasers. Any amendment to the strata roll or the building plan after the sale has begun, you need the consent of every individual purchaser. So if you have had 200 people who have already purchased, and then you want to go and make an amendment, you need to call back those 200 people individually and get all their consent. If you do not get their consent, then whatever amendment you make is not valid. Having said that, of course, it is very likely, it is possible that the local council may overlook such things and they may approve any of these transactions, because after sales has begun, the local council which approved the building plans and issued the development order may not be aware of who has purchased a property, what is their address, how to contact them. They will rely on the information given by the developer. And it's possible the developer may mislead them. In the process of misleading, gets all the approvals in, and before you know it, approvals have been done under your feet without your knowledge and over your head as well, right? So you are hit both below your feet and above your head. But the JMB must take all necessary remedial action. The JMB is the beneficiary for whom the developer is holding on trust. And don't forget, another issue, important issue, is a common property defects account, right? So since the JMB is the one that is going to manage the place, if you look at your statute again, what does the Act say regarding the duties and powers of the joint management body? It says the duties of a joint management body in section 21, sub 1 says, is to properly maintain and manage the building or land intended for subdivision. So when it comes to the common property, because it is the JMB which is going to maintain and manage the common property, they will have every right to take action against the developer for any defect in the common property, because ultimately the money will come out of their pocket. So if the JMB finds that the swimming pool is leaking, sometimes the swimming pools built over car parks and then the pool is leaking, cars get damaged. You have to get an expert opinion report. If it is a structural damage, then the JMB can sue because they are the ones who have to maintain. The money will have to come out from their pockets, from the maintenance fund, or if it's a major repair, it's from the sinking fund account. The same goes with the lift. The same goes with every common facility that can be found there. The developer will be liable for all these during a certain period of time, of course, during the warranty periods and things like that. So the JMB has a power to recover because they can be regarded as the beneficiary and the developer as the trustee of this. Now, if you uh, can, please just go and look up the case. I've mentioned this case in many of my seminars before. Malaysia Land Properties, Sdn Bhd, and Waldorf and Windsor in 2014. So Malaysia Land Properties and Waldorf and Windsor in 2014. In this case, the Court of Appeal clearly held that the developer holds the common property on trust for the JMB, right? Of course, in this particular case, the developer had converted one of the floors into a parcel, right? Converted it into a parcel, but the JMB fought for it and they wanted it back. And of course, a big tussle went on in the courts. In the High Court, the judge asked for the building plans. He even asked for the promotional booklets, the marketing materials. And the promotional booklets and the marketing materials all showed that the sixth floor, the sixth or seventh floor, was actually supposed to be a games room. It's like a games room, easy room, where you can go and relax. And therefore, it must have been a common property. Furthermore, looking at the accounts of the developer, if that unit belonged to the developer, that floor belonged to the developer, it would have been listed as an asset, but it was not listed as an asset. And because it was not listed as an asset, so it doesn't belong to the developer. So the management body managed to get it back from the developer. The title was nullified because there was fraud committed on the land office. And so the title was nullified, converted back into common property. One of the developers' argument was that they reserved this as their own, that they did not sell this part. So the developer gets this idea that this project is my project. Whatever I sell belongs to the owners, the individual parcel purchasers. Whatever I don't sell remains with me. That is wrong. That is wrong. You have parcels, you have accessory parcels, you have common property. Parcels are sold. Together with it comes your accessory parcel. Common property held by developer for JMB, subsequently transferred to MC. Apart from these, as a result of amendments, now you have whole floor parcels. If the entire floor is a car park, like in malls and shopping plazas, the entire floor becomes a parcel, you will have a separate title for it. Then it will not be accessory, but it will be a separate parcel by itself. And if the developer doesn't sell that, then he will have to pay the maintenance charges for that entire floor parcel. There is no such law that anything unsold belongs to the developer, unless it's a unit. If it's a unit, unsold unit, it belongs to the developer. Together with the accessory, it will belong to the developer. But any part which is a common property, which is not parcel, which is not accessory, which is not an entire floor parcel, is automatically common property. As common property, it must be handed to the JMB. The developer holds it on trust for the JMB. JMB manages it. JMB has a right to collect rentals, provided they follow the procedures, and when the time comes, it's handed over to the MC. So basically, this is something we must learn. The developer cannot do as he likes during JMB period, right? I bring this up because there's nothing in the act which says developer holds on trust for JMB, whereas for MC is clearly provided common property vests in the MC, and maintenance account is open in the name of the MC, sinking fund is in the name of the MC, although developer maintains. But when it comes to JMB, nothing of that sort is mentioned. So I hope this enlightens you to a certain extent. I can't go into depth today, so my time is limited. So thank you very much for joining. Right? If you have any questions, I don't mind taking up some of your questions. Thank you. Thank you. Can't hear you.
Okay, thank you, Mr. Patrick, for
Yeah.
your sharing for today. So, okay, next we go to Q&A session. Hold on, eh? All right, okay. So, the question is from Miss Mizadi. When is the deadline the developer to file with COB a certified true copy of true audited accounts together with the auditor's report?
Well, the law just says that they have to. Okay, the audited accounts are presented at every AGM. So when it is presented at the AGM, then subsequent to the AGM, once it has been passed, right, then they have to submit it to the COB. That is what it provides for. Now, usually they are supposed to submit within 14 days. They may go up to 1 month, but if they do it, well and good. And that is what the developer is supposed to do. Not only the developer, it is also the JMB which has to do it. Also, the MC has to do it. All of them have to do it. That's what it is all about, right? Okay.
All right. So, okay. Next question is from.
Okay. Yeah. Maybe before we go to the next question,
Mhm,
Miss Miza, maybe to clarify
mhm,
further, if you have your Strata Management Act and you look at Section 14, this is during the developers management period. Section 14, subsection 1, paragraph C says, file with the commissioner a certified true copy of the audited accounts together with the auditor's report within 14 days of the accounts being audited. This is for the developer. So if your question
mhm,
is specifically, I think what's the deadline for the developer? Is for the developer. So remember there are no AGMs during developer management period. So since there's no AGM, there's no one to approve it. So
mhm.
once the auditor's report is out, 14 days from the date of the auditor's report, they must file with the COB. Right.
Okay. All right. So, next question is from Farid. Developer is duty bound to establish board's maintenance account and sinking fund account during the management period before JMB assess. What is the implication of such duty if the developer's management period falls within the exemption period?
Can you please? I need an explanation on that exemption period that they are referring to.
Mm-hmm.
I need explanation there. Is it exemption from setting up the JMB, uh, or it is for what? If you can tell me which exemption period you're referring to, I may be better able to answer.
Mm-hmm. Um,
So maybe I'll wait for an explanation for that exemption period.
mhm. So we got no next question. So we
Hmm.
hoping Mr. Farid to answer this question. Yeah.
Yeah. The exemption period you're asking is for what? It's about what?
Yes, for JMB, Mr. Farid replied.
Oh, yes, that means, yeah, they will have to establish. In fact, right from day one, when they're handing over vacant possession, they already have to establish, because Section 13 of the Strata Management Act says they are not to collect any money. No person can collect any money either for maintenance or sinking fund unless you have opened a maintenance fund and sinking fund account. Okay, so of course they have exemptions for those which are older projects. Okay, older projects, but we take it by now. The basic rule is you cannot collect money without opening the account. So there's no way a developer can actually collect money. And I say no way legally it's not right lah. He cannot collect any money, right? Without opening your maintenance account and your sinking fund account. So even if the JMB first AGM is delayed, let's say because the law is once you give vacant possession within 12 months, you must call for the first AGM of the JMB. However, assuming times are bad, 1,000 units are there, and key has been given only to 10 people. So very obviously, it doesn't make sense to call for an AGM of 10 persons, when the rest of them have not come in yet. So you may ask for exemption. Give us extra 6 months. But during this extra 6 months, the developer has to continue with the maintenance account and the sinking fund account. He will continue until the first AGM of the JMB. Once the first AGM of the JMB is complete, everything transfer to the JMB. You see? So most of the time, what the JMB does is they just take over the account. Then they go and change the signatories. That's about it. Right? Okay, I hope that answers your question.
Mm-hmm. All right. Okay. So next question is from Loh Cheng Cheong.
Mhm.
What is the consequence of developer didn't attend any JMB meeting during JMB management period?
Well, rule one is when you don't attend a meeting, you are going to be bound by whatever decisions that are taken, right? So the
Mm-hmm.
developer cannot say he doesn't know or anything like that. And there can be penalties, but those penalties don't come within the Strata Management Act because the Strata Management Act just says that the developer has to be part and parcel of the meetings and part of the JMB, part of the JMC as well, right? They're supposed to get involved in the decision making process. But just like every other owner, if you don't attend, what do you want to do? Then the JMB has to go ahead and make whatever decisions they want and then compel the developer to act according to the resolutions that have been passed. Yes.
Mm-hmm. Okay. So from Loh Cheng Cheong also, Form 4, handling over from developer to JMB, some of the items is not available during the time. Example, strata rule. And developers keep to execute Form 4 until the complete documents available. And what is the consequence for not performing Form 4?
Okay. These are, of course, difficult questions. Most of the time, when Form 4 is being handed over, there are many documents a developer may not have. But why, after the amendments in 2015, no developer should be able to complain that the strata roll is not ready? Because the strata roll, the building plan, and the development orders are supposed to be displayed in the marketing office. So, what is the excuse for saying that it is not ready? Right? We must not accept whatever lame excuses the developer gives as some kind of absolute truths. What do you mean by it is not ready? Unless the developer has gone into liquidation and the liquidator has taken over, then maybe there could be some delay. But if you don't have Form 4, right, handover, there's going to be a lot of difficulties. Now, let me give you one example of an actual case which I did. Since the case is over, I can mention about it. It is PJ Center Stage, where the JMB actually sued some of the unit owners, parcel owners, commercial parcel owners, because they had illegally extended the central cooling system to their individual parcels. Most of these owners were actually subsidiary companies of the developer. So they had been riding free for many years, having free aircon because they were using the centralized cooling system. When the JMB discovered this, then the JMB called in their experts, calculated back charges, charged them, they didn't want to pay, and we filed the case in court. I was the counsel in the case, I appeared in the case, and one of the issues was that the expert came in. The expert spoke about the manual, the aircon manual, the complete manual for the building, and because the capacity and all the other things about the aircon system, the cooling system. And in his report, he said the report clearly specified the manual that the cooling system is only for the common areas. Every individual parcel will have its own individual air conditioners. Pipings are done, but as far as individual parcels are concerned, they must have their own aircon. Now, the defendants argued that the manuals were only a guideline and were not actually binding. Now, we were able to counter this by two things. Number one, whatever you buy from the smallest product, from your handphone, a new handphone which you buy, right up to big things like a car or corporate things, they always have manuals. And you're supposed to look at the manuals to see how something works. They always ask you to read the manuals first, right? That's number one. So in the manual, the manufacturer of that product will specify what is the capacity and the capability of that product. So from the manual provides a very important aspect of it. Number two, if it was merely a guideline and it was not binding, then why did the developer in Form 4 actually specify the manual as one of the items handed over to the JMB? So because it was one of the items listed in Form 4, therefore, both in the High Court and in the Court of Appeal, we won our case because the court accepted that the manual was actually binding. It was handed over in Form 4. Now, assuming for a moment it was not in Form 4, then it becomes debatable whether the manual is actually a mandatory document or not a mandatory document. That could be the impact of not having a Form 4, right? Okay.
Okay. Next, what if JMB didn't invite developer for the JMB meeting?
Okay. Number one, the JMB has no business saying they don't want to invite. The law specifies that very clearly. Okay. If you look at this thing, that there shall be a joint management body. Okay. In section 17, subsection 4, it says the joint management body shall comprise the developer and the purchasers. Now, section 22, right, regarding the joint management committee, okay, also clearly provides for this. So let me tell you that you can't override what a statute provides. The statute provides that the developer is part of the joint management property. Because in section 22, for joint management committee, section 22, subsection 1, paragraph E, the constitution of the joint management body and the joint management committee shall include the developer. Shall means mandatory. If the JMB does not invite the developer, this is a very serious error on their part. And the developer can take issues with the JMP, not only JMB, JMC also, for not calling them for the meeting because they have a right to be there. It's one thing for the developer not to attend. It's another thing for you not to invite. They don't need to be, actually, they don't need to be invited. They have to be given notice of every JMB meeting, EGM, AGM, and every JMC meeting as well. It is mandatory, right?
All right. Okay. I bet that's all. We get That's all the question for today. All
Right.
right. Next, I would like to take this opportunity to invite all of you to our next CPD seminar. If you guys interested to join, please do contact us, or you guys can visit our Facebook page, Excel Academy of Real Estate, to find out more. That's all for today. I'm Ashikin. Thank you again, Mr. Patrick, for your today's sharing. And thank you everyone for joining us today. Hope to see you guys again next week. That's all. Thank you, Mr. Patrick.
Okay, welcome, welcome. Thank you all for joining in, and thank you for your questions as well. Right.
All right.